We find ourselves in a pleasant situation today. If it's anti, we are celebrating something odd, something new, and something wonderful. Wonderful in the sense that we've come to a realization that there is need for us to take heed, not just of what is ailing our country, but to name it and to have a day when we ponder and give ourselves time to think of the advances that have been made, the changes that we've seen, the daunting task that is before us, but also alongside it, people who are at the heart of fighting this menace that threatens to derail our whole country, and that is corruption. And with us this morning is the Chief Magistrate in the Anti-Corruption Court. Actually, I wasn't quite sure how to address one. Well, let me just call him Justice Douglas Ogoti. I don't know. I was reading this morning, and Justice almost called you Your Majesty. Then I realized, no, that would not be appropriate. So,
are you even justice?
Well, he dispenses justice, so he is a justice. However, yes, I'm simply saying what went through my mind this morning, given what I was reading. However, it is an honor and a pleasure to have him. It is a task, an onerous task, and probably a very thankless one. And it's a task that falls on the shoulders of many people in this country who sit in this position, but more so on the shoulders of Douglas Ogoti, because he is the Chief Magistrate in this court that sees all the heavy-duty corruption cases at this court. And at the end of the day, they come before his court. And it is his rulings that sway and hold. Justice, I'm going to continue calling you Justice until you correct me.
Your Eminence.
Yes.
Your Majesty.
That is a good prayer, by the way. Yeah, one day I'll become a judge. Yeah?
Sooner rather than later.
Yes.
Let me start by asking this question that has again been on my mind as I was thinking of the many things I was thinking. This is a daunting task. What would you say are some of the most challenging things that come along with this job of yours?
Wow, there are many.
Yes.
First of all,
yes,
you lose your social life. Yeah, you lose your social life because of the kind of work you do, because of the kind of people you interact with. You are never sure who is your friend and who is your enemy. So you lose your social life totally.
Wow.
Yes, that is one and most daunting issue. It's gone. So you don't expect that we meet and have coffee somewhere open? No.
So every time you are out there, you're basically looking and wondering, so does this person represent some interest? Will this person appear before me tomorrow? And will I be expected to treat them differently? This is a daily challenge that you have to go through.
It's a daily challenge that we all go through in the anti-corruption court, yes.
So, Honorable Ogoti, not knowing what is who is a friend and who is an enemy, the enemy, as we've seen it, has been corruption for a very long time. And even as we are commemorating this day and, setting reminders and renewing the commitment and such, what kind of challenge has it been dispensing justice when it comes to corruption in the country?
Now, Kenyans have very high expectations. It's like an accused person should just be brought to court, he's charged, he's sentenced, and hanged. And yet there is what we call due process. Yeah? We've got to go through due process as provided for in the Constitution. Article 50 is very clear. So we get all tirades of manners against us. Nobody appreciates. But then now, what do? You've got to balance the act. You've got to balance the issue of fair trial. You also have to balance the issue of public expectations. That is actually a very big challenge, even before you go to the cases themselves. Yes. So it's a very big challenge. Very high expectations. Yes?
I'm saying the judiciary many times has been named as the bottleneck in the fight against corruption. And it has been said in no uncertain terms in terms of convictions by people in their minds. What would you have to say about this?
Now, I joined the anti-corruption case court 3 years ago. There was the issue of the judiciary being the weakest link. But let me ask you, what is the last time you asked for data from the anti-corruption court?
Myself personally? I
No,
wouldn't
I
be able-
mean, like,
Actually,
No, I wouldn't say that I have.
no, I wouldn't say we've asked for data. Would you recommend that we do?
yes. Yes, I'm inviting you all to come and check our data for the last at least 2.5 years.
Yes.
The issue of the judiciary being the weakest link or a bottleneck is an old adage. You can speak to the DPP, you can speak to the EACC, you can speak to all stakeholders. That court has really improved. And then I would wish that anybody saying we are still a bottleneck or we are still the weakest link, let him come with the data from our court for the last 2.5 years. Yes. We have improved from a disposal of cases of about 30-35. We are now heading to 70% of our cases. Yes. So I'm speaking from a point of view of having data in our possession. I wish you had asked me, but if I talk about data, I'll talk about percentages. Yes. So when there was, I also discovered, you know, the way Kenyans are, we discovered that some people use the issue of the judiciary being a weak link to propel their own interests. Now, let me give you an example. Just one scenario. The Constitution provides for hearing of a case within reasonable time under Article 50. The accused is also given the right of a fair trial that is inderogable. You cannot take that away from him. Now, the scenario is this. For confidentiality, we don't discuss cases, but I can give you data.
Okay.
Where you have that 38 accused persons, where you have 55 witnesses, where you have 25 advocates, all these are entitled to hear the case and for the advocates to cross-examine on behalf of the accused who are 55. Let's say each accused cross-examines for about 6 hours. Can you do your math and tell me what reasonable time is? Again, look here, we are human beings, and you see, corruption is in the mind. Don't forget that there are those who would want to scuttle the process by making so many applications, which they are entitled to.
Yeah.
Once an application is brought, like there's a case now, before it hasn't started hearing, its proper hearing, but there have been 15 applications. And you see, these 15 applications, you've got to go and write rulings.
Yeah.
In this, when you write rulings at our level, we are not entitled to researchers. I've got to go back and do my own research. It takes time. Then all our processes, I take notes in hand.
Yep.
Yeah? I take notes in hand. It takes time. There's one of my colleagues who has already written 3,000 pages. And being human, during the court process, don't forget that there's the issue of sickness. A judicial officer like myself could be sick, that leads to adjournment. The advocate could be sick, that leads to adjournment. The witnesses could be absent for one reason or another. And then sometimes when they feel that I've delivered a ruling that is not right to them, they go to the High Court, which is their right.
Yeah.
The High Court says, before I decide this, I have to stay this matter. A stay means you actually block the case as long as it's in the High Court. Now, can you then say, these are some of the things that the common man does not know. Where is that weak link?
How is that the corruption, the court then, the judiciary being a bottleneck? I hear the frustration that you're talking about. There are a couple of things that are emerging.
Yes.
One is
Yes.
capacity and the resources that the judiciary has. Therefore, that
Yes.
the judiciary is able to deploy, for example, to an office such as yourself, the Chief Magistrate's Court. And then the other
Yes.
one is the officers of the court who know the kind of hurdles that you have to jump and you have to go through than playing the system and frustrating the process of dispensing of justice. So let's start with this latter part, where you can clearly see that these are officers of the court, the lawyers who are coming here, the prosecutor, or even those accused, and they're trying to game the system so that it takes forever to dispense with this case. How do you deal with those, knowing full well that what they're trying to do is basically playing the system?
Now, you see, when you are a judicial officer, there is really nothing much we can do. But because the law provides for all theatrics that happen in court, if you come to court and see what is happening when a lawyer stands up to address the court, all those scenarios are provided for. Again, one other thing I would wish to communicate is that anti-corruption cases are not ordinary cases.
How so?
Anti-corruption cases, yes, I'm coming to that. Anti-corruption cases, unlike cases under the penal code, hizi wanasema cases za jinai under the penal code, are not the same. Anti-corruption cases deal with figures. Anti-corruption cases deal with public officers. Anti-corruption cases deal with documents. Usually you've had this issue of procurement. Most cases come from the process of procurement. From A to Z, procurement starts with requisition up to payment. About 12 processes in between that are recorded. It's not like an assault case. You meet somebody there, you've had your beer or so, you throw a punch, you hit that guy, and then you find yourself in court. No. These are cases where documents are in place. Now, why do I say they are not like ordinary criminal cases, which have been going on? The law that has been, I think the law that the Mwananchi knows is under the penal code. Now, if there is a law, and I'm suggesting to our parliamentarians, please give us a law that guides anti-corruption cases. Because assume you are a CEO, like some of the cases that are going on, I think if you've been careful, you've seen like now the case of KEMSA. I can comment on it, even because it's not in court. You saw the issue of procurement. All documents are there. By the time the investigator finishes that case and forwards to the DPP, he's in possession of all those documents that were used. Because you cannot do anything in government service without putting it in black and white. We wish that a law is brought to let me use the word expose, because if I use some legal terms, it could be a bit difficult. Let them expose that evidence at the earliest opportunity. Why am I saying this? The law governing exposure of evidence, otherwise called disclosure in court, is the old law, whereby you're charged, and then it's that after some time is when you are shown the evidence against you. That leads to delay, because I have seen some investigators, and this, if anybody is listening and is an investigator, I'm saying it without prejudice. You tell after plea, you give them 14 days to disclose, because the Constitution in any case says that Article 52J, that evidence to be used against the accused shall be supplied in advance. Ideally, the High Court has said advance should be, some decisions have said at plea, some decisions have said 14 days after plea. But anti-corruption, what I'm saying is that the evidence in anti-corruption cases is known from the word go. And in fact, those guys committing that crime know that they are not doing the right thing. Why can't parliamentarians pass a law that requires, once you are charged, evidence be disclosed? And then again, there has been the issue. These are my suggestions, very clear issues, because I've come across them. There is a debate that going on that the anti-corruption cases should be given time limit. If you look at the case scenario I've given you, how will the parliamentarians come to the time limit? It's very difficult, because there are those cases with one accused person. There are those cases with, I have another case with about 40 accused persons.
What?
So what we need is a law, just like the election law, governing procedure from charging to judgment. That is the only way people will stop throwing tantrums at one another. But the way the law is now, you'll never stop guys throwing tantrums at one another. Because like now, if we have a crooked IO, he'll sit on evidence, and there's nothing you can do, because you cannot throw out a case. And he knows maybe for one or two reasons, he's keeping the evidence in the drawer, in the closet. Yeah, so we need a law that compels all arms of government. You know, justice is a chain from the report office to the prosecution. There are so many agencies involved. It should touch on what each agency will do. I'm telling you, if that is brought, I think the corrupt have a reason to worry.
So, Honorable Gotti, what I hear you saying is that the law as it is being used by individuals to kind of make these cases go in their favor. And a favor would be maybe a stay. A favor would be throwing a case out completely for lack of evidence, for example. So using law as it is what's happening, why it could seem as if the race to fight corruption is actually slowing down.
Yes, if like now you've heard of cases, a person being acquitted, and the matter has been in court for the last 1 year. Yeah, sometimes even the DPP does not know what is going on in court. If there is a corrupt fellow, my friends, if there is a corrupt fellow, you'll be the CEO sitting there, but you don't know what is happening in court.
Yeah.
You read in the papers that so-and-so has been acquitted. Why? Because of lack of evidence. And first of all, that file went to the DPP, and the DPP was given evidence. Yeah, they have very professional officers who give opinions on whether to charge or not. So why should a case be thrown out because of lack of
Evidence.
witnesses? Yes. So there must be some crooked person somewhere
playing the game.
And I'm speaking this because initially I was a prosecutor. I know what happens. Yeah, you can't bring a case without evidence. In fact, like when you are charging, a report and the initial investigations will show you that prima facie there is a case. But then, when the law changed now to require that all files pass through the DPP, I know that once he gives consent under Section 35 of ASECA, he has the evidence. So what happens in court is something else.
Yeah.
Yes. Because a case cannot stay honestly in court for 1 year without calling even a single witness, no.
Bona Chief Magistrate, there is the National Council for the Administration of Justice, which brings together very many other actors, the judiciary, the DPP, the DCI, and others. Has this matter been discussed by NCAJ, to the best of your knowledge, in how best then you can streamline the speedy prosecution of corruption cases?
Now, unfortunately, I don't sit in the NCAJ. I don't know. I don't know whether it has been cascaded there or it has captured their attention. But it's one thing we are seeking to bring up, because we really feel that a time has come that the law should be amended to reflect all that I'm saying.
Okay.
Before you get to the NCAJ, we have our local NCAJs. We call them CUCs, Court Users Committee.
Yes.
What we are planning to do is to call a Court Users Committee and then cascade that issue up to the NCAJ. Yeah, it starts from the station level. They may not be aware because that is a very high organ up there.
Would you say, sir, that the funding that is allocated to the judiciary is adequate for the tasks that are required of them?
Wow, that is another problem. You see, when you are a judicial officer, you know all that you want. From the background I've given you, I can add one or two things that we are lacking, that when we seek for, we are told funding is not enough. And having been in government for that long, I know what my bosses talk about. Let's now look at the issue of researchers. Why can't all officers actually have researchers?
Yeah.
It will lead to quicker dispensation of justice. I record my proceedings in hand. We have no stenographers. The other day, I asked for the speech-to-text application. There are no funds. Now, how do we move along?
You know, as you're saying, you write everything by hand. I was thinking, are you not allowed to record it digitally or use some recording device? Are you not allowed at all?
No. The law, everything has to be controlled by the law.
I agree completely.
The law has not reached there. Even when COVID came in and we tried to go virtual, before the Chief Justice gave the directions, advocates were up in arms. Your Honor, we don't have the law, so you can't do that. And honestly, we don't have the law, so there's a problem in that. Yes.
So what I am seeing, the bottleneck appears to be Parliament. Because it's, it's in Parliament where laws are made.
They have a biggest monkey here.
Yes. I mean, it's being passed on to the judiciary, but I asked the question because in the absence of adequate facilitation, it is not possible for the mandate to be carried out adequately.
No, it's not. Honestly, I can tell you, because if you look at the nature of cases, Hello?
Yes.
Yes.
Yeah, if you look at the nature of cases, and we are also required to perform by doing so many cases. In one case, I took a witness for 1 month, just one witness. So even the magistrates that are at the anti-corruption court are not enough. Yeah, because you can hear a case continuously for 2 years. Yeah. So we need more staff. Yeah. That is not something to beat about the bush. So long as we don't get resources, it will be slow. But if you get resources, nowadays investigations have really improved. The prosecutors are really good. If you look at our data, that has enabled the court also to dispense justice. We are now heading at 70% of disposal of cases. But what I'm saying, if we get more resources, we'll move faster. And again, there's the issue of small and big fish. Our reasoning is that corruption is in the mind. To us, there's no small and big fish. But you guys in the media usually go for the high-octane cases.
Yes.
Governor so-and-so has been charged, leaving so many other cases down here. So that is really another problem that puts a guillotine along our necks. And you see these very rich guys, they are entitled, as any other person is entitled. They hire the best lawyers in town. Yeah, those good lawyers come with applications, and there are many. They come with applications and counter-applications, and they're entitled to. What do you do? So if really the system wants to improve, I think there should be more provision so that we get enough judicial officers. Yeah, because once, the law requires us to hear cases on day-to-day basis. We do something that is called a pretrial. Once a person is charged, we require the DPP to disclose. The DPP discloses, and after due diligence, and everybody has been involved and certified that there is proper disclosure, even the accused is certified that I have all the documents, I have all the evidence, then we agree on a day for trial on daily basis. So like now I have a case I've fixed up to June. If that case flops, then on that day there's nothing you are doing.
Of course.
Yes.
It's unfortunate.
So you can see, yes, we need more staff to be handling these cases simultaneously.
Honorable Douglas Ogoti, thank you very much for sharing your experience with us, for sharing your zeal and commitment to the fight against corruption in the country. Honorable Douglas Ogoti is the Chief Magistrate in the Anti-Corruption Court. We'll be speaking with you again soon, sir, and we hope that we'll be able to get you.
Thank you.
Thank you very much.
Thank you very much, sir.
Asante sana.